Hey, welcome everybody. Welcome to the first ever YouTube Live for Children of Darkness and Light. I'm Lori Hellis. I'm your host. And this is where we talk all things Vallow Daybell. I'm your host. And this is where we talk all things Vallow Daybell. I'm your host. Let me just get rid of that echo. Hopefully you can all hear me. Please let me know. Sounds like I'm coming through. So we're going to talk lots of things about the Daybell case. Just because I'm a retired lawyer doesn't mean that we're only going to talk about the legal stuff. But I think it's important to demystify that process for our citizens and those that are interested in people in access to justice. So first of all, tonight, I want to thank my moderators, Brown Eyed Girl and Michelle R., for jumping in to moderate this first ever live. I suspect that our comments are going to run pretty quickly. So if for some reason we don't catch your question or your comment, please repost it and feel free to post it in the comments below because I will read and answer every one of them. I appreciate everybody being here tonight because I have so much to talk to you about. We had a series of hearings yesterday, and there's a lot that came out of those. But before we start, please like and subscribe because we'd love to have these videos move up a little higher in the YouTube algorithm. Also, please, I want to remind you that Lauren Mathias at Hidden True Crime has a new premiere. I'm going to have to look the name up, so bear with me. Has a new premiere interview coming out with Debbie Heisler, who is a kidnapped survivor, I believe. And so don't forget that we're going to end in time for you all to roll over to catch that. I also want to remind everybody who's going to be in the Boise area that we are having a reception and to kick off this great new launch. It is going to be at 10 Barrel Brewing, which is one of my favorite places. And it will be tomorrow night and the information is on the screen. Please come down and join me. It's a no-host reception, and come and go as you like. Just come on down and have a beer, and I'm really excited to meet and get to know more of the people who are my neighbors who are following and interested in the case. So I hope you all will join me. Please send suggestions for production to us because this is all new to me. So if you've got suggestions or complaints about the lighting or the sound, let me know because it's all kind of a grand learning process, and I definitely want to make the show better. So with all of that said, I want to dive into what happened yesterday in court. As you all, a lot of you probably know, I'm a retired criminal attorney. I'm writing a book about the case, and I filed some motions to open some sealed documents in the case. I think that the judge in this case has filed has sealed an extraordinary number of the filed documents. And so I filed motions to unseal those documents. To say that Judge Boyce wasn't too excited about the motions would be an understatement, but he did hear them yesterday, and I was happy with the outcome. The recordings of the hearing were released yesterday. They're on several channels that you can find. I know that Nate Eaton has them on East Idaho News. Scott Reich has them on his channel. So I haven't uploaded the recording, but it is out there if you want to hear the recording of the arguments from yesterday. The court did get those recordings out to the media pretty quickly after the hearing, because, as you all know, the judges decided not to allow cameras in the courtroom. So the first up on the docket was my motions. The judge was not too excited about hearing them, but was a little bit confrontational about why I thought the motions should be unsealed. Ultimately, he decided he would take it under advisement, not a surprise. But also, I pointed out to him that the last order that he issued was actually done in the proper format and in the proper way, with a paragraph redacted of sensitive information. And that, to me, proved that he must have known he was doing the wrong way, because he's corrected it. And so, in my mind, had conceded the point that they had not been following the law. So that was kind of interesting. He did say that he was going to go back and review all the sealed documents and determine how much could be released, potentially with redactions. One of the troubling things for me is the fact that we know that there is a gag order in this case, that the people who are involved in the case are under a gag order, but the gag order itself is sealed, which is very strange. So after the judge heard my motions, he then went on to take up all the other motions that have been filed in the last couple of weeks. And he started out with a motion that was filed either late Wednesday night or early Thursday morning, because it went before the judge, but there was hardly any record of it. And that was a motion by the prosecution to also stay Chad Daybell's case. And it was an odd request. It's unusual because the judge has repeatedly said these cases are going to be tried together. And yet, as we'll see when I get to the next item, a lot of things are not being done together. The cases are not being treated as cases that are joined. So the prosecution asked for Chad Daybell's case to also be stayed. Lori's case has been temporarily stayed while we wait for her to have another mental health evaluation. And so it was sort of interesting. The judge, first of all, John Pryor objected strenuously, and the judge agreed that there was absolutely no basis for a stay in Chad Daybell's case. It's interesting that, and John Pryor made the point that he thought that this was a clever tactic to avoid the court making any decisions on all the motions he'd filed. I couldn't disagree with that. Say what you might about John Pryor. He tends to be a little dramatic in court. He tends to be he puffs a little bit, but he is a competent lawyer. He does know what he's doing, and I'm certain has been seeking the advice of death penalty qualified attorneys. We're going to get to his motion to continue in a minute. But the court said no, he wasn't going to stay Chad's case, that Chad's case was going to go forward, and he was going to make some determinations. That hearing was going to happen on the motions, and he was going to render some decisions. The other thing that John Pryor brought up, which I thought was very interesting, was that he has not been involved in any of the hearings having to do with Lori's competency. He has been completely excluded from that, which I find to be highly unusual. If you have a joint trial and one of the defendants has a competency issue, I think it's very unusual for the other attorney to be excluded from those discussions. Every attorney has the same obligation to keep confidences and it would be just as prohibited for Mr. Pryor to discuss anything having to do with Lori's mental health issues or her medical conditions as it would for her attorneys. So I don't really understand why the judge has pretty systematically excluded him. And I thought that was interesting. He said that they were keeping him in the dark. And I thought that in a way, his exclusion was yet another argument for the severance motions. So then they had to take an off-the-record sidebar. And this happens pretty regularly. I'm just going to see if I can catch a few of the comments. This happens pretty regularly. And one of the reasons is because of this secret gag order. So when it got to the point where they needed to discuss the motion to continue, and one of the things that John Pryor said was that he had not received all of the discovery that he was entitled to. And that prompted them to go into a closed door session and to come back out. What came out in the hearing, and I think is probably the point of contention, you may all recall that there was a motion some months ago to use up some forensic evidence to complete some testing. So there was a motion to allow them to fully consume a sample because the sample's so small. And so, or would otherwise be destroyed by the testing. So sometimes that comes about if you have a fingerprint that has touch DNA on it, because when you test the DNA, you're going to destroy the fingerprint. Sometimes it comes about because the DNA sample is so small that there's only one opportunity to test it. So what ultimately came out was that consumptive testing had been, they reached an agreement on how that consumptive testing was going to happen. And the state sent that information out to the lab for testing. But it has not been returned, and no one is certain when it will come back. Once that happens, then John Pryor should have the opportunity to hire his own experts to also analyze that raw data. So Lindsay Blake made the point that, well, we don't care that much because if it doesn't come back in time, we won't use it. And John Pryor just about launched himself out of his chair. Because rightly so, he said, it's not a matter of whether you want to use that information or not. It's a matter of, I have to have it. And the reason why is it could potentially be exculpatory. I mean, what if that consumptive testing proves that somebody else, it's somebody else's DNA? That's important for John Pryor to know. So there was a kind of a heated back and forth. The judge agreed with John Pryor that it did not, that it was not a matter of whether or not the prosecution was going to offer the evidence at trial. It was a matter of assuring that John Pryor received all of the discovery before the trial. So I'm leafing through my notes from the trial. The judge, in talking about the continuance, said that he was concerned about the arrangements that had been made with Ada County, and that it could be some time before they can get another court date in Ada County and rearrange all of the arrangements they've made for the January trial. He talked about the fact that there might be a lengthy delay, and he questioned whether or not Chad Daybell would be willing to wait in custody during that lengthy delay. John Pryor said he had had that discussion with his client, and his client understood and was in agreement, and Chad nodded his head. Chad was there, Lori was not, because Lori's case has been temporarily stayed because of the mental health issue. We have yet to see Chad and Lori in the same courtroom. Since the judge decided to take the issue of the continuance under advisement, I think he intends to inquire from Ada County when they might be able to reschedule it. He also agreed that he was going to put a hold on the deadline for juror questionnaires. So when a case is getting close to trial, both sides submit to the court what they think will be appropriate questions to ask a juror, a potential juror. We saw some motions from Jim Archibald saying that he didn't believe that the jury should be asked about the death penalty because death penalty qualified juries tend to convict more often. So they're going to continue to work on their jury questionnaires, and they will be, the judge will then determine what the shape of that jury questionnaire will look like. Now, that doesn't mean that the attorneys won't be able to question the jury when they start jury selection, but by requiring the jurors to fill out what could be a lengthy jury questionnaire, they're able to start sort of understanding a little bit about each juror before they start the questioning. So the next motion was for John Pryor to receive a transcript of a grand jury proceedings. For those of you who've been following the case for some time, you might remember that the indictments for the murders were sent to the grand jury, and that grand jury convened in May of 2021. They met for about 3 days, and after that, they issued indictments for both Lori and Chad. Then, in December of 2020, December of 2022, I believe, that grand jury was reconvened for a day. We heard that from sources, but it was never confirmed by the prosecutor because grand jury proceedings are secret. So John Pryor said he understood from the discovery that he had in his possession and the information that he had been told. Sorry, I have barking dogs. I'm so sorry. I'm home alone. My husband's out of town. And so I don't have anybody to ride herd on the pack of dogs. So as I was saying, John Pryor asked for a transcript of that grand jury. The grand jury was reconvened and they heard evidence for a day. There were no indictments that were issued or no different charging documents that were issued as a result of that grand jury. The rules say that if indictments issue, the defense counsel can request transcripts of that grand jury proceeding. But because there were no indictments issued from this grand jury proceeding, the DA's office said, you don't get them. So after some discussion, they went back into another chambers discussion because grand jury proceedings are secret and that it shouldn't have been a public discussion. And they came back and it was agreed that although the grand jury was a secret proceeding, whatever the grand jury had heard was from witnesses who had previously been witnesses in the prior grand jury proceeding, and that the evidence that they heard was relevant and touched upon Lori and Chad's cases. And in that case, the judge ordered that John Pryor should get a copy of that transcript. Now, we have no idea what's in that transcript. I've heard some rumors, but we don't know for sure what is actually in that transcript and what that grand jury heard. So going forward, John Pryor will be able to review that transcript at his own cost. That transcript has to be made at their own cost. So the next thing they went on to was the issue of a bill of particulars. And my last newsletter talked a bit about bills of particulars. It is not in Idaho a legal filing that there is a law that covers it. There's no rule or no law that permits the defense to ask for a bill of particulars. So there is one Idaho case that talks about a bill of particulars, but there is nothing that says that that you are required to do it. So everyone recognized that it was at the discretion of the judge. And I thought Rachel Smith did a good job of outlining the law and making a good argument for the fact that it was a creative way for the defense to get at what is attorney work product, which is privileged, and get them to sort of outline the theory of their case. And I suspect that it's probably true. That's one of the things the judge took under advisement. And so, I'm sorry. The court denied the motions for bills of particular. So the judge then said that given the issues of the potential for setting the trial over, that he wanted to set a scheduling meeting in January, and he also, after requests from both the defense and the prosecution, said that he would finally set a schedule for motions. It's unusual that he has not at this point set a motion schedule, because in most cases, and especially in complex criminal cases, the judge will set a schedule and say, you need to get all your motions in by X date, and then the other side is going to have 30 days to answer. We're going to have a hearing, and then forever hold your peace, unless it happens to be a motion that can be filed anytime up until the day of trial, like motions to sever. So John Pryor filed a motion to sever the cases. It was unlike his previous motion. It was well thought out. His previous motion was very general and not very well supported. This, on the other hand, was a very specific and very well supported argument. In his motion to sever, he talks about the fact that he is going to likely be bringing information in and defenses in which are going to disadvantage a co-defendant. Likely, he is going to bring in the defense that it wasn't Chad that did it, it was Lori and Alex. I certainly think that is one of the things that may have caused Lori to emotionally tip over, was the idea that Chad was potentially going to throw her under the bus. So I think I think when we think about her hair tie wedding ring, I think that she's extremely distressed by the possibility that um, that Chad is going to go his own way. So there is a November 10th motion hearing at 9 a.m., and that is going to be to hear the motion to sever as well as to set some motion deadlines. The judge did say, I'm going to set the motion to sever over because we're now looking at different trial dates. So we don't know. We don't know what the judge is going to be able to find out from Ada County as far as when they might be able to reschedule a hearing, and we don't know how far that might be out. I suspect it will be next fall, October of 2023. That seemed to be a date that was sort of bandied about a little bit and discussed. So I'm thinking that may be where the judge is aiming, if in fact Ada County can accommodate it. It is proper for arguments and discussions to be done in chambers under some circumstances. It was absolutely proper for them to go into chambers and have a discussion about the future of Lori's, her stability and her mental health. It was also absolutely appropriate for them to go into chambers to discuss the grand jury proceedings, which are by statute secret. But there are also some other questionable things going into chambers, and that's because of this secret gag order, which everybody knows is out there, but nobody has seen. It's buried in one of those sealed documents that just says order. I am very hopeful that Judge Boyce is going to reconsider his decisions on some of those and at least release some information from those sealed documents. I don't believe that we're going to get a complete picture of all of those sealed documents until after the trial. But keeping documents sealed beyond a trial, other than documents that are specifically protected by the statute, like Lori's mental health, is next to impossible. So at some point, those documents are going to be unsealed. So that was sort of a wrap up of the hearing, and I spent some time in Rexburg. I was able to visit with several people in Rexburg who are people who are close to the case and interested. I was surprised to see Kay and Larry Woodcock there. I wasn't expecting them, but I was pleasantly surprised to see them there. One of the things that a lot of people have asked about is the fact that John Pryor makes a very pointed effort to call Lori Vallow and not Daybell. In one instance, early in the hearing on Thursday, yesterday, he said Mrs. Daybell and then corrected himself very pointedly and said Mrs. Vallow. It's very clear that John Pryor is attempting to distance Chad from Lori and trying to downplay the fact that these people are married. I do believe that John Pryor's defense, probably not unpredictable, but his defense is clearly going to be, I was this poor sap who was blinded by this beautiful woman, and she and her brother did terrible things that I didn't know about, and it's all on them. So it doesn't surprise me. It was very upsetting to Larry Woodcock, who very pointedly said she does not deserve to use the name Vallow. She killed the man whose name was Vallow, and that would be Charles Vallow, her fourth husband. So I'm going to take just a second and look through the questions and see what I can find. Does Idaho have any statutes about victims' rights? Can Kay and Larry retain counsel as interested parties representing the victims? And Laura Ferris said, had to do it for our case to get it to move. I don't believe in the state of Idaho that they can come in as interested parties. They have a victim's advocate. She was there with them. Victims advocates typically work for the prosecutor's office. I know that Kay and Larry have expressed a tremendous amount of frustration that they are not able to get the children's remains and to have a funeral. That is not at all unusual, and I know that it was very distressing to Kay and Larry that they were unable to. It was really distressing to them to have the case appear to be moving out, because delaying the case just means a longer delay before they're going to be able to bring some closure to this. So I know that it's hard for them. I know that I am hoping that the prosecution may be able to come up with some sort of resolution for them that would give them some peace of mind about going forward. But I don't know. It is not at all unusual for prosecutors to say, we are not turning loose of that evidence. It's very difficult for the family to think of their loved one's remains as evidence, but it obviously is, and it cannot be released until everyone is sure that no one else is going to request any sort of additional forensic testing, have a second autopsy, any of those things. So while I understand their distress, I also understand it from the position of the prosecutors. Oh, here's a good question. If I were Chad's defense attorney, how would I handle the case? I think that the only available defense for Chad is the one that John Pryor is aiming for, and that's, I was totally in love with this woman. She swept me off my feet. I believed everything she told me, and I didn't do it, but they did. As I put in my newsletter, we defense attorneys always called that the Saudi defense. Some other dude did it. And it is a very common defense. In fact, there is a whole rule of evidence and the whole concept of what's called reverse 404B evidence, which is evidence of bad acts by other people to prove that they were the bad guy and not you. So, they likely will bring in evidence about what happened in Arizona, about Alex shooting Charles Daybell, or Charles Vallow. Oh my goodness, I'm so sorry, Charles Vallow. And I think they will have to bring in that evidence. There will be they will bring in evidence of Alex's behavior, him shooting at Brandon Boudreaux, him shooting at Tammy, as a way to say, really, this was all their doing. Because I don't know that there are many other defenses available to him. So let's find some other questions. While I'm doing that, please like and subscribe this video so that we can get a little higher in the YouTube algorithm. Oh, good question. Can indictments still come from the last grand jury proceeding? Yes, although it depends on how long it's been. Because there are some instances where they might say the information is so old, we call it stale, and that that there needs to be some update to the presented to the grand jury before there could be another indictment. I have a bit of speculation about what was going on in that second grand jury. And I think that it has to do with Chad Daybell's son, Garth. And I think that we'll see Garth testify at trial. So I don't know yet what might have been involved, but we do know that Garth was there the night that Tammy Daybell died, or the morning that she died. And we do know that he has said that he helped Chad lift her body off the floor and back onto the bed. We don't know how much more he was involved, but that's purely my speculation that last grand jury had to do with him and with the circumstances surrounding Tammy Daybell's death. So if the indictments aren't stale, there still could be indictments to come out of those grand jury proceedings. Let's get irrefutable evidence that convicts these two. Well, unfortunately, we have to rely on the investigation and we have to rely on the prosecutors to come up with that irrefutable evidence. We don't know what the prosecutor has, and I can tell you honestly, people who I have talked to who are close to the case, who are close to law enforcement, have said, you know this much, there's this much. So I am counting on the fact that the prosecutors and the investigators have much more information than we've seen and feel confident that they can wrap this case up with a conviction. Kathy says, I've always supported whatever Kay and Larry want to have happen in this heartbreaking case, and I wish the kids would be released. And I completely agree. I understand that this has continued to be a horrible hardship for Kay and Larry, and I agree. I hope that the prosecution may be thinking about some creative ways to make that happen. It's, I think, not enough to just say, I'm sorry, you have to wait till the trial's over. I think that it would show a tremendous amount of good faith for them to come up with a way to set Larry and Kay's fears to rest and let them be able to find some closure. But that is entirely up to them. Can you tell us your opinion about Judge Boyce without bashing him? I think he's afraid to make a big mistake because he has no experience in a multiple murder case. So here's what I'll say. Judge Boyce was a magistrate, which is a lower court judge. They handle lower court matters. He was elevated to the district court in late 2019, and then in early 2020, COVID pandemic hit and everything shut down. So he does not have a vast experience with complex criminal cases. And he has not, as far as I know, tried a murder case, let alone a multiple murder case. So I think that he is operating as cautiously as he can, trying not to make any missteps that are going to cause an appeal. And I think he's acting out of an abundance of caution. I think, we all make mistakes, and we all sometimes have to go back and say, if I'd had the opportunity to do that, I would have fixed that, or I would have done it a different way. And sometimes we have to step back and say, I need to rethink this. I hope that as time goes along, that's what he's doing. I don't think that Judge Boyce is a bad judge. I think that he is he is a very straightforward judge. He He is courteous on the bench. He's not, he doesn't belittle people from the bench, or a lot of, like lot of other awful judges do. So, I mean, I don't have bad things to say about him, but I think that we also have an obligation to hold our public servants to a high standard and to say, we need you to follow the law. So I have a little dog who is scratching at my office door, and if I don't open the door, she's going to continue to scratch. So just 1 second. I hope by next Friday, I'll have a dog wrangler here who can keep track of these guys. I have 2 Labradoodles, and they're very friendly. You might see them walking around in the background. As I was saying, I don't think that Judge Boyce is a bad judge. I think he's an inexperienced judge, and I think as time goes on, he's going to gain confidence, and he's going to gain wisdom as he goes along. So let's see what Debbie has to say. If they go with the death penalty, would it also include a lesser sentence of life in prison? Well, I think she continues to ask, in the Casey Anthony case, she got off because they went for death, and the grant and gave the jury nothing else to consider. You're not wrong on that. That's true. And thanks for the question, Debbie. In the Casey Anthony case, what happened was they went for first-degree murder, a capital charge, and there was evidence that came out that it was possible that Kaylee was killed in an accidental way, and that then her death was covered up. And but the charging document only said first-degree murder. There wasn't a lower degree, a second or manslaughter kind of charge. So the jury couldn't go back and say, we think that we don't think she committed first-degree murder, but we think that she was reckless, and somebody left the pool ladder up and the little girl drowned in the pool. And so we think that was reckless, and so we could find that she committed manslaughter. But they weren't given that option. They didn't. It wasn't charged that way, and so they didn't receive that jury instruction. It was either first-degree murder or nothing. First-degree murder carries the death penalty. Lower second-degree murder, manslaughter do not. So in that case, they only had one choice. In this case, we have multiple charges. We have conspiracy charges. We have murder charges, we have financial fraud charges. So there's an array of things that they could be convicted on. It's not really going to be an all or nothing. But it's unlikely that they would be given any sort of a jury instruction on a second-degree murder or a manslaughter either. Now, in Idaho, which is unusual, it's different than a lot of states. In Idaho, you can only get life in prison without parole if the DA has asked for the death penalty. I think that's a mistake, and I think that's something that is probably going to change in Idaho, because it is very difficult. I think that we are seeing a huge decline in the death penalty. We are seeing the death penalty really go the way of the dodo, for lack of a better description. We're seeing the death penalty fall out of popularity. We're seeing many more states that are either doing away with the death penalty or have a death penalty memoriam in place. The reason being that administering the death penalty, lethal injection, has become very difficult. The companies who make the drugs that are used in lethal injections are becoming more and more resistant to having their products used for that purpose. More and more medical people are saying, I won't participate. It is getting more and more difficult to carry out a death penalty, even if you get one to a death warrant. I mean, I know of cases in Oregon where people have been on death row for 30 or 40 years. And even without a moratorium, they still don't have death warrants because the appeal process is so lengthy and so moves so slowly and is so expensive. So I think a lot of states are going to be moving away from the death penalty. And I think Idaho is likely to change their statutes so that you can get life without parole without having to request the death penalty. But in Idaho, in this case, the way it works now, in order for them to in order for Chad and Lori to get life in prison without parole, one of two things has to happen. Now that the state has requested the death penalty, the state can make a deal, a plea bargain for life without parole instead. Or Chad and Lori can go to trial, and after the trial, if they are convicted, then in the mitigation stage, they can prove to a jury that they shouldn't receive the death penalty, that there is some mitigating circumstances that mean that they shouldn't get the death penalty. So and I think we're going to see more and more states move away from the death penalty because it is so expensive. Death penalty cases, the average death penalty case to get it from indictment to trial costs $4 million. After trial, post-trial, you're looking at it potentially up to another $30 million in the cost of appeals. So it makes no sense. It costs a fraction of that to house someone in a life without parole situation. So let me just run through a few more questions. There's a question here about whether Melanie Gibb might be a witness. I absolutely think she will. I don't know how valuable she is going to be because she's been out there, and there's a lot of she did after Chad's preliminary hearing, she did an additional interview with the Arizona authorities, and some of her answers in that follow-up interview were pretty interesting. So, and there's also that telephone call that she had with a friend from Facebook who recorded that call, and there's some pretty damaging information on that. So it'll be interesting to see how credible she is at trial. Does that quieted grand jury mean someone else will be charged? Oh, I think there's a potential that someone else could be charged. Some people have said they thought that it potentially was Melanie Pulowski, and some have thought that it could be Garth. So we don't know what came out of that. Now, I will say that I have seen situations where the district attorney sends an issue to the grand jury. The grand jury brings back and says, yes, we think there's probable cause, sufficient evidence to bind this person over for trial. And then the district attorney takes that information, back to that person and their attorney and tells them, if you agree to come and testify, if you agree to come and provide us with evidence, then we won't drop that indictment. So it could be that someone has been that was brought before that grand jury, and the prosecutor's just sitting on that potential indictment, because that does happen. Every time I lean forward, I turn into a gremlin here with the light. Okay. We just answered that one. I do want to talk a little bit about Lori and the issue of her competency. I've been involved in a lot of cases over 27 years, and I've been involved with quite a few where competency was an issue. I happen to be one of those who doesn't necessarily think that Lori is faking. Is her condition not as bad as she makes it seem? Possibly. But what I know about the way the process works is that the state has a group of forensic investigators, people like John Mathias, who are on their panel of forensic investigators who routinely assess people's competency. And when the DA says, we need to have this person evaluated, that's the point at which somebody from that panel who is highly qualified is selected to go and evaluate the person. Because the people who are doing these evaluations routinely do them for the state and are very capable, have to meet certain educational and experience criteria, I think it's very likely that we can trust whatever evaluations that they do. Now, I think it's very difficult to malinger long-term. I'm not going to say it doesn't happen, because Brian David Mitchell, who was Elizabeth Smart's captor, did it. And he led people on for years that he was insane, and it turned out he was faking. And a very savvy psychiatrist, was finally able to trip him up. But I'm not sure Lori's sophisticated enough to do that. And I'm not sure, I do believe that she likely has a mental disease or defect that makes her incompetent at this point and unable to aid and assist her attorney. Now, that does not mean that she is allowed to use a defense that she was insane at the time that the crime was committed, because Idaho doesn't really allow the death penalty. There are some exceptions to that, which we can talk about probably in another video. But I do believe that at this point, she is not competent. My observation when I observed her in court was that she was very drugged. And a lot of those things that people interpreted as her smiling and her laughing and her seemingly pretty carefree, and what I saw in that was that she was very medicated, and it would have been really difficult for her to behave any other way than kind of a flattened affect and sort of a almost giddy mood. Now, that's not to say that she doesn't like the limelight and that she enjoys being in the spotlight, because that's absolutely true. I mean, nobody would argue with that. But I do think that there are genuine concerns about her competency, only because I know the way the system works. And I know that the people who do those assessments are every bit as qualified as John Mathias. And I trust him to do that kind of assessment, hands down. So I really think that I think that she needs to go back for additional treatment. The other thing I'd say is that what we know about psychotropic medicines would probably fit in a thimble. And it is not at all unusual for people who have been using a medication to have breakthrough decompensation. And it's also not unusual for those meds to stop working because their brain chemistry changes. And that completely changes the way that they react to any psychotropic med. So I'm not surprised. That's a good question. How did it feel seeing Chad, Judge Boyce, and the lawyers in person? Now, I had seen the lawyers in person at the last hearing I attended, but I had not seen Chad in person. And it was interesting. During the time that the lawyers stepped back into the judge's chambers and Chad was alone at the counsel table, even looking at his back and his shoulders, you could see his level of discomfort. Larry and Kay were sitting just a couple of rows back, and at one point, somebody who was wearing one of our bracelets leaned over and said, "Here, go give that to Chad." And people were talking about him, and he was sitting right there. It was clear he could hear. And you could just kind of see his shoulders hunch, and he was quite uncomfortable when his lawyer wasn't there. So when I argued my motions, it was very clear that Judge Boyce was not happy. He had a really set chin, and he certainly was. He was going to get his questions of me. But I think as time went on, I pointed out to him that essentially he'd conceded the argument by changing how he's doing things. And so I think ultimately he was willing to back down, which, to be able to admit your mistakes is hard. And so I think I made the kind of progress that I was hopeful for. So, that's a good question. And the answer is we don't know yet. The judge deferred the motion to sever the cases until he had more information about when a case might be set next year. So we don't know yet. That motion is going to come up on, I'm just double checking my notes here so that I don't give you incorrect information. That motion is going to come up on November 10th at 9 a.m. So as far as I know, he has not made any decisions, and I think he really wanted to have the opportunity to talk to Ada County about scheduling and about how setting the trial out might impact. Because we don't know whether Lori will be competent by the time Chad is tried. And that, in essence, severs the cases. That said, I do think that John Pryor made some compelling arguments as to why the case should be severed. And in my eyes, I think Judge Boyce should grant that severance. I know that the prosecution doesn't want that for many reasons. They make the point that it is burdensome on the taxpayer, but there are alternatives for them where they can go back to the state and ask for relief and assistance, financial assistance from the state for these unexpected, unanticipated expenses having to do with this trial. So I don't think that's particularly an issue, but I do understand that when you separate a trial and you have witnesses coming who are going to testify at two trials, you have witnesses who have the opportunity, even subconsciously, to sort of replay in their heads and the first time they testify, they're nervous and they go home and they think, oh, I should have said this, or, oh, well, I wish I'd done that. And so when you have a second trial, you have the opportunity to do that. And it's not really about changing your story or about lying as much as it is about accounting for the environment and the questions. And so I understand that the prosecution doesn't want to do that. They don't want to give up that advantage. But on the other hand, justice may very well dictate that two trials are going to be necessary. So it may very well be that we see Chad's trial set and then Lori's trial set at the point that she becomes competent. We don't know yet. So I hope that we will have an answer to that after the November trial, but we don't know, or a hearing, but we don't know yet. Oh, there's another question about how it felt to meet everybody in person. So I've been hoping that I would keep these lives down to an hour. I want everybody to have the opportunity to migrate over to Lauren and John's channel once we're finished here. Lauren's TGIF tonight is a recorded interview with a woman named Debbie Heisler. It says it's a story of survival, so that looks really interesting. And she is scheduled to start that at 8:15. So I'm going to try and take a couple of more questions, and then we'll wrap up for the evening. So let me slide down here to where. Here's a question. If Judge Boyce releases the documents, will anyone be notified, or will I need to periodically check to see if they're unsealed? I suspect that he will quietly drop the revised documents, particularly if they include anything embarrassing. So I think it's going to be up to me and to any of the other news agencies and people who are involved in the case to keep following it and keep checking periodically. Because I don't think he's going to advertise that he's posting new stuff. Oh, in the courtroom, we couldn't see Chad's face, so I don't have any idea whether he was smirking or not. It's so hard when you are in court, and I'll just use my own example. I've been a trial attorney for 27 years, and you get used to going to court every day, speaking up in court, talking to judges, and it becomes really second nature. And so I didn't have any butterflies walking into the courtroom. We all sat down, but when they called my name, I suddenly got nervous. And when I stepped up to the podium, you could tell I was nervous. It was frustrating for me how nervous I was. And that environment for people who are, and I'm experienced, and that environment is familiar to me. So I think sometimes people get into these environments and they really don't realize what their faces are doing. They don't realize how they're responding and what they look like. I don't know whether Chad smirks because he's thinks he's got it all wired or because he's not that smart, or if it's just because he's really, really nervous. So I don't really know. I think that'll be an interesting thing to watch if the trial is televised, because the one downside of being in court as compared to it being live streamed is that the cameras can focus and show the people who are before the court from the front. And when you're in the court, all you really see is their backs, the back of their heads. Although you do see the faces of the witnesses. So let's see here. Oh, I just showed that one. Oh, good question. I think the only DNA testing, the question is, why is the prosecution and the defense putting off the DNA testing? I think the only DNA testing which has not yet been done was the issue of this DNA that this testing that could or would fully consume the DNA, the forensic sample. And so they argued about whether or not that testing was going to be done. It took quite a long time. And then they finally figured out a way for that testing to happen that was acceptable to both sides so that they could validate and make sure that that testing was being done properly. So it's just those samples, which I think there are two, that have not yet been tested. And DNA testing takes time. Even when you put a rush on it, it takes time. And if those DNA tests don't come back maybe till next month, then John Pryor still has the right to have his own expert examine. They can't re-examine the samples because they'll be consumed, but he will be able to analyze and examine all the raw data that came out of that DNA testing. So, there's a lot of analysis that goes into DNA after you get the raw data. And so his expert would have the ability to do that. But they're running out of time. So I don't know that they put off doing it, although I will say that most prosecutors are not going to order consumptive testing unless they absolutely have to. Because if this issue comes up on appeal, there's nothing for anybody to retest. Or if for some reason a new trial is ordered, either it goes up on appeal and the appellate court orders a new trial, or there's a hung jury, or there's a mistrial after the jury's seated, and they have to try the case again, that DNA testing would not be available to be retested. So I think most prosecutors are a little cautious about consumptive DNA until they absolutely have to. So it's not a surprise that they're waiting until the last minute to try to analyze this specific DNA. Wow, we've had some great questions in the chat. Here's a good question. Lori, if the grand jury had to do with Garth, don't you think Garth would have shared that with Chad and John Pryor? it's possible that he did, and it may very well be that that's how John Pryor knows that Garth was involved in that grand jury, if in fact he was. But it still means that John Pryor needs to have that transcript so that he knows what was said in that grand jury, because that is a proceeding that's under oath. And it's always important to know what people are saying under oath. Just like it's important to know what they were saying during the preliminary hearing, because all of that information, all of Melanie Gibbs' testimony, that all was testimony under oath, which means that if Melanie Gibb, for example, were to come into trial and say something different than what she said in the preliminary hearing, they could use her sworn testimony in the preliminary hearing to impeach her credibility, to say, okay, were you lying then or are you lying now, Lori or Melanie? So that's important. And it's important to know what kind of sworn testimony has happened ahead of the trial. So that about brings us to enough time for folks to roll over to visit with Lauren and to catch Lauren and John's live or their premiere, actually. I do want everyone to know that I will go back through the chat and make sure that I've caught questions. Please, if you have questions you feel I didn't answer, post them in the comments and I will be looking for those and answering those. I do want to point out that our little logo here is Tylee and JJ, and that's part of the reason why we're here, is to make sure that we are that we are a voice for victims and that we are seeking justice for them as well. I just want to thank everybody who put up with my dogs barking and my technical glitches and joined us tonight for this very first YouTube Live. I appreciate all of you who've been here, and I hope that you've subscribed, that you've hit the like button so that you'll and the notification button so that you'll get notifications. My plan is to do a live every Friday night, 6 o'clock Pacific, and then that will sort of lead everybody to have time to roll into John and Lauren's Friday night TJIF if they'd like. I appreciate everybody that was here. Thank you so much. Have a lovely weekend, and we'll talk to you next week.